Well, hello, and welcome back to another exciting edition of Coffee with Stephen. So this week's blog deals with a court case that the Second Amendment community sort of underwon this last week. It's called Rupp versus Becerra. This case, which was filed in district court in Orange County, had to deal with an analysis of the assault weapons regulations. So for those of you who were interested in possibly registering your AR-15s as assault weapons, the regulations themselves and the methodology necessary to register your firearms were being challenged. Judge Stanton, who was an Obama appointee, essentially said that the regulations themselves are perfectly acceptable. Now, one of the big contentions associated with the regulation requirements were that you needed to provide to DOJ specific information on how you received the firearm initially. Now, if you received the firearm from a firearms dealer, say a year and a half ago, there was a high probability that you could go back to that firearms dealer and get a copy of the DRO's paperwork, assuming that you didn't keep it at the time of the initial transaction. But for those of us that might have purchased firearms, say 6, 7, 8 years ago, very few people actually retain that paperwork. There's no statutory requirement that says that you have to. And yet, the only way that you can register your firearms as assault weapons is to provide very specific documentation as to how you acquired it. And if you just sort of guess, you're effectively committing perjury. So the analysis that she undertook had to deal with different levels of scrutiny. And specifically, she was talking about whether or not this was a core fundamental right as it relates to the Second Amendment, essentially articulating that it is not a core fundamental right to have an AR-15. She then went through an analysis of intermediate scrutiny. Now, that's a little complex in and of itself, and you probably glean a lot more. Frankly, I think that her initial assumption that it's not a core right was problematic to begin with, but her analysis of the proper level of scrutiny required to determine whether or not a challenged statute falls outside the scope of constitutional muster, I think was fundamentally flawed. Now, that all notwithstanding, one of her big arguments was that the legislature had a substantial interest in ensuring that these firearms were regulated, and that the idea of having some sort of mechanism that would slow somebody down in reloading, hence bullet button or the new bullet button 2.0 that requires a cracking of the action, was a legitimate state interest. Now, the irony is that since she's effectively closing off an avenue for registration where the individual would be able to use a bullet button, it effectively puts them into the position where they have to go with either a fixed magazine or alternatively featureless. And if they go featureless, that means by definition they don't need to have any sort of locking mechanism for the magazine. Ergo, they can have a traditional magazine release. So even though she's trying to adhere to the desires of the anti-gun crowd, she might have inadvertently put herself into a position where she's essentially advocating the idea that we should all go featureless and thereby enjoy the benefits of having traditional detachable magazines. In any event, read the article. It's fairly lengthy and it goes through a lot of sort of legal wonkish stuff, but hopefully it does a pretty good job of explaining what actually took place. As always, if you have any questions or you want to contact me, you can do so at stephen@artemishq.com, or you can go ahead and you can swing by the Artemis Defense Institute yourself. In any event, train constantly, train consistently, and train with purpose. Above all else, stay vigilant. Until next week, stay safe.